Hello, this is Mr. Seymour, and what we're going to do in this lesson is look at civil rights. Civil rights as opposed to civil liberties. With civil rights, you're looking at the rights of groups of people. You're looking at the treatment of minorities and how we allow them a say in this system of polity where we have to allow for every voice to be heard. So we're going to look at the background of civil rights in this lesson, and then we're going to go on to look at some issues dealing with civil rights that your author talks about, and some considerations of how civil rights are applied to different groups. So let's look at a video very quickly from Ferguson and take a look at where civil liberties and where civil rights are meeting these days.
That's intimidation over there to me. And that's what this is about, intimidation. Why can't we fix it and make a dialogue instead of that happening? Why don't they come and walk with us? You can't keep telling these guys, be quiet, don't curse, pull your pants up, this, that, and the other. This is their everyday life, and they mad. They're mad. I'm mad. We should all be mad, man. We should all be angry because of what's going on right now.
The cops harassment is frequently. It's all through the day, it's all through the night. Then they not beating us physically, they doing it verbally. I don't know what's gonna happen, man. This been going on before Michael Brown. This been going on before Trayvon Martin, before Emmett Till. You know, it's been going on for a long time. You're just sick and tired.
You must disperse immediately or be subject to arrest.
So just listen to what they say. Step back. We don't need you in jail, brother. We need you out. We need you in jail. Our family needs you.
This is not open for discussion. In a peaceful manner, you must disperse.
How can we feel like we can have free speech if there's a guy staring down a sniper rifle as we speak?
This ain't about just Michael Brown no more. It's bigger than that. This for the injustice that's been done to all the black men that's been killed by police.
So we forced to do what we do. And we gonna make noise, and they gonna hear the outcry and witness from Michael Brown.
Shoot! Hands up! Don't shoot!
I see you. Shoes wide up. I see you. I know where you at.
I know that many Americans have been deeply disturbed by the images we've seen in the heartland of our country as police have clashed with people protesting. Today, I'd like us all to take a step back and think about how we're going to be moving forward. There is never an excuse for violence against police or for those who would use this tragedy as a cover for vandalism or looting. There's also no excuse for police to use excessive force against peaceful protests or to throw protesters in jail for lawfully exercising their First Amendment rights. And here in the United States of America, police should not be bullying or arresting journalists who are just trying to do their jobs and report to the American people on what they see on the ground. Put simply, we all need to hold ourselves to a high standard, particularly those of us in positions of authority. I know that emotions are raw right now in Ferguson, and there are certainly passionate differences about what has happened. There are going to be different accounts of how this tragedy occurred. There are going to be differences in terms of what needs to happen going forward. That's part of our democracy. But let's remember that we're all part of one American family. We are united in common values, and that includes belief in equality under the law, a basic respect for public order, and the right to peaceful public protest. So now's the time for healing. Now's the time for peace and calm on the streets of Ferguson. Now is the time for an open and transparent process to see that justice.
So the brief video that I just showed you is from this summer in Ferguson, Missouri. And Ferguson's right outside of St. Louis, and there was a young man, Michael Brown, who was shot by a police officer 7 times. The allegations that have been coming from there is that the police in that particular town are very discriminatory. It's 97% or 98% white, and that African Americans in this predominantly African American community have become prisoners in their own homes and mistreated, and that this is stuff that's still going on in 2014 that was going on 55 years ago. So this is where civil liberties and civil rights meet. What liberties do those people have to protest, and when do those liberties exceed the standards of expectations within our community? And where are there civil rights? And remember, civil rights are due process rights that are given to you as a group. So we're talking about, in civil rights, the protection of a status within a minority group. So this is a poster or a bulletin board, billboard from Arizona, from a recent law that was established in Arizona that says basically, have your papers ready, racial profiling ahead. This is a reaction to laws that have been established there that require police officers to ask anyone that they suspect of being in the country illegally for papers. Well, who are they going to ask? Is it going to be the blonde-haired, blue-eyed person that's here illegally from Sweden, or is it going to be the Hispanic American that was born there in Phoenix? That becomes the issue and the question as to how it's going to be implemented. And if it's implemented in a way that targets one specific group, then it's a violation of civil rights. So critics of this 2010 immigration law in Arizona worried that it would subject Latinos to racial profiling. One group opposing the law sponsored this billboard in Phoenix to draw attention to their concerns. Supporters of the law, like Phoenix Sheriff Joe Arpaio, who claims himself to be the toughest sheriff in the country, argued that strong measures are necessary to discourage illegal immigration. Next, we're going to look at the context of civil rights. Civil rights is not civil liberties. Civil liberties would be your protection to protest, your protections if you are accused of a crime or arrested. But civil rights are your protections as a group or whole. In general, civil liberties refer to the freedoms that are promised in the Bill of Rights. Civil rights revolve around the Equal Protection Clause of the 14th Amendment to the Constitution. So we need to remember that slavery was part of the New World from 1619 until the Emancipation Proclamation 260-ish, 255 years later. Slave trade was ratified in the Constitution, although it was to end in 1808, it didn't. You remember that we had the 3/5 compromise at the nation's founding, where slaves were 3/5 of a person for representation. Thomas Jefferson said, I tremble for my country when I reflect that God is just, that his justice cannot sleep forever. He owned slaves. He never emancipated his own. He also had a relationship with one of his slaves for over 30 years and fathered 6 children with that slave, Sally Henning. And Sally Henning, we now know from DNA, her children were related to Thomas Jefferson. They were his children. The Missouri Compromise of 1820 limited the expansion of slavery above a certain line of latitude. The numbers between 1619 and 1808, with the end of the slave trade, were between 600,000 and 650,000 humans enslaved and brought in from Africa as chattel to be bought and sold. But then after 1808, even though we will come to a point where we stop the importation of slaves, what's going to happen is that the breeding of slaves and the sale of slaves will actually gain even more importance in the South, because this invention in the 1780s called the cotton gin came along. The 1860 census showed that 2.3 million slaves lived in the Deep South, which was 45% of the population of southern states. In 1857, we have Dred Scott versus Sanford. The Dred Scott versus Sanford case stated that blacks had no rights which the white man was bound to respect. From the early 19th century to the mid-20th century, most of the America's focus with respect to civil rights issues has been on African Americans, but now we have other issues: women, gay, lesbian, and Hispanic, for instance. In 1860, Lincoln was elected, and this leads to the South seceding from the Union and starting the Civil War. The period of Reconstruction, which will come from 1866 to 1877, would give blacks new political power in the South. But after 1877, when the carpetbaggers leave, the blacks are nearly universally disenfranchised through a series of laws. Disenfranchised means they are denied the right to vote. The tools used included a poll tax, because African Americans did not have the money. If you were white, you probably had much more property and money than if you were black. The grandfather clause said that if your grandfather could vote legally, then you could not be stopped from voting. But of course, African Americans, their grandfathers couldn't have voted legally because they would have been slaves. Literacy tests. These were exams that were administered at poll booths, testing detailed knowledge of civics, usually targeting black voters, and some of them were really bad. Some of them could be as bad as being asked to identify the number of bubbles in a bar of soap or the number of holes in the ceiling tiles. So this is the era of Jim Crow. In 1883, the Supreme Court holds that Congress did not have the power, as it did in the Civil Rights Act of 1875, to forbid racial discrimination in a private business. Even after the passage of the Emancipation Proclamation, which is actually an executive order that applied only in the South, during the Civil War, progress towards equal treatment was very slow. And the South would pass a number of laws that would legislate towards what we call de jure segregation. De jure segregation Let me see if I can write this for you. De jure segregation is spelled like this. It means segregation by law versus de facto segregation, which is segregation by practice. So this is de jure segregation, where there are laws being made to segregate. Plessy versus Ferguson would actually enshrine the separate but equal, which basically means separate bathrooms, separate water fountains, separate everything. And Jim Crow laws would give blacks a inferior treatment, and that would be, for example, let me clear the screen here. Okay, so we're clearing the screen. That would be, for example, public schools. Black people, African Americans, had to go to public schools that were much worse funded and ramshackled. In the late 19th and early 20th centuries, at least until the landmark case of Brown versus the Board of Education in 1954 would come along, and this is what really makes the difference. So it isn't until 1954, with the case of Brown v. Board of Education, which overturns the Plessy versus Ferguson rule that established Jim Crow laws, that we start to see any kind of progress. Now we need to look at Native Americans as well. Native Americans are systematically removed from their lands and often eradicated. They were brought to reservations, which prevented them from voting until 1924. Most treaties that Native Americans signed with the U.S. government were broken or ignored. And then we look at Latinos. Lately, Latinos have recently become a political force in American politics, especially as their numbers have grown. But Latinos vote at a lower rate than African Americans. And 1/3 of Latinos are not citizens. They are more politically diverse than African Americans. And think about this. You have cultures in Argentina, Cuba, Panama, Ecuador, Honduras, Mexico. Each is different. For instance, a Hispanic in the state of Florida would most likely be Cuban or maybe Panamanian. Cuban Hispanics tend to be incredibly conservative versus Hispanics in say, the southern United States, southern border of the United States. With Mexico, they tend to be more liberal. And of course, this is Cesar Chavez. Si se puede. We can do it. Looking at women, the Constitution did not give women the right to vote until the 19th Amendment, which was ratified in 1920. So a woman was not considered a person under the 14th Amendment. It wasn't until a good 50 years later. The rationale was paternalistic, meaning protected by men. The idea that women are better off by not engaging in politics. The men should do that. They should stay in the kitchen. Then we have gay lesbian rights. Gays and lesbians are the most recent group to struggle for civil rights. Started with the Stonewall Rebellion in 1969. Support for gay rights has grown substantially in the 40 years since, but there's been a lot of de jure segregation which has been allowed to exist in state laws, particularly in a state like Texas, that do prohibit gay rights. And it was illegal for a consenting gay couple in Texas up till like 2006 to even consummate their relationship. There were sodomy laws which had been overturned. All right, so I want to look at a video here. This is a timeline of civil rights that I put together for you. So this is about 3 minutes long. Let's watch this timeline, hopefully.
People get ready, there's a train a-coming. You don't need no baggage, you just get on board. All you need is faith to hear the dealers humming. Don't need no ticket, you just thank the Lord. So people get ready for the train to Jordan. Picking up passengers coast to coast. Faith is the key, open the doors and board 'em. There's hope for all among those love the most. There ain't no room for the homeless sinner who would hurt a helpless just to save his own. Believe me now, have pity on those whose chances grow thin. For there's no hiding place against the kingdom's throne. So people get ready, there's a train coming. You don't need no baggage, you just get on board. All you need is faith to hear the Jesus humming. Don't need no ticket, you just thank the Lord.
So the question becomes, where do we go from here? Are we returning to an era where we've forgotten the use of police dogs and fire hoses and threats of violence and bombings? Do we have to go through this era again? So the effects of slavery and the Jim Crow laws are still evident, particularly in the area of education. Some critics would say especially in the area of public education, where they still contend that the public schools are unequal. But it's inequality on the basis of income and opportunity. Active discrimination still exists. Hate crimes. Look at the debate about hate crimes. No one denies that there is still racially motivated violence. The only question is, what is an appropriate punishment? Now, we do tend to take a harder stance because we can't ignore it anymore, but it still exists. So I'm going to show you a couple of charts. This one shows the percentage of people in poverty in 2010. And I want to show you that if you look particularly at southern states, you will see that most of those southern states, many of the ones that left the Union during the Civil War, have higher levels of poverty. Here's Washington, D.C. over here also. Over 16%. Now look at something else. If you look at the percentage of people living in those states that have white majorities, you will find that less than 50% of the population is white. The majority of the population is Latino, African American, Asian. So the argument that is being made in these two charts is that there's a direct connection between race and poverty. Is that true? That's something that's really hard to say. Is it access to education? Is it access to jobs and employment? Is it cultural? Is it language in the case of Hispanics? There's a lot at issue here. But we do know there's a racial divide. A substantially lower turnout rates among minority groups cause minorities to have less of an input into the laws that are made. Some of the reasons that we can look at are differences in education and income, a lower number of polling places in minority areas, the withholding of information about voting and registration from minority communities. 3 times as many black families as white families are below the poverty line, yet probably 3 times more white families vote than black families, and 4 times more white families vote than Hispanic families. And the poverty rate of Hispanics is certainly no less than those of African Americans. The black male unemployment rate is twice as high as the white adult male unemployment rate for similar age groups. The criminal justice system tends to be very harsh towards minorities, especially black males, which is one of the reasons that we saw those riots in Ferguson. And the accusation of racial profiling often targets minorities. It used to be that African Americans would say, well, they were victimized for and pulled over for driving while black. Now Hispanics are saying they're being victimized and pulled over in Arizona for driving while brown. Is it the same thing? Are immigration laws or the laws that Arizona wants to institute, which would have police officers who are not federal officers enforce federal immigration law, would that or should that be happening? African Americans are not only more likely than whites to be convicted for similar crimes, but they're likely to serve longer sentences when they are convicted. Hate crime victims are disproportionately racial or ethnic minorities. There have been substantial improvements in overcoming the gap between political, social, and economic conditions of race, but still we haven't reached pure equity. So, for instance, it's no longer legal to discriminate in offering housing. You can't redline housing areas and say this is white and this is black. Admissions to universities have been equalized through a mixture of legal and cultural change. But then now there's a lot of backlash against the methods used by those universities because they say that it becomes reverse discrimination or reverse racial profiling, that it's easier to get into some universities if you're a minority than if you are white. So despite the call from the Supreme Court for what they called colorblind society, we do still tend to notice race, and we still use it, even if it's in the back of our minds, we still use it. In 2003, in a Supreme Court case of Gratz versus Bollinger and Grutter versus Bollinger, the affirmative action policies that take race into consideration in the colleges on undergraduate and law school admissions decisions were ruled unconstitutional. It was unconstitutional to apply them. Some people take race into account with the intent to discriminate against those from a particular racial background. Far more do it unintentionally or unknowingly. So now we get to the case of Fisher versus the United States, which happened at the University of Texas. And Miss Fisher wanted to be wanted to attend the University of Texas, but she did not make the University of Texas's. She didn't make the top 10% list in her school. And UT at that time was going with a top 10% rule. It said that if you were in the top 10% of your graduating class, as certified by your high school, you would be offered automatic admission. However, she said that when she put in her application, she was up against minorities who had much lower ACT, SAT scores than her and lower grade points than her, and that those minorities were offered space in the freshman class at UT, and she was not. In this case, though, the court found that institutions must provide what they called affirmative action practices that are narrowly tailored to specific needs. They sent the case back to the lower court, so nobody won. Now, this is a picture from the lunch counter riots, or the lunch counter protests in the civil rights era. So the strategies that were used during the civil rights movement: social strategies, nonviolent protest, sit-ins like in Woolworths in Greensboro, North Carolina. The Freedom Riders convinced President Kennedy to enforce Supreme Court decisions that banned segregation in interstate travel, and they risked their lives to do so. While the experience of African Americans is unique in many ways, culturally and historically in the United States, they are not the only minority to have seen discrimination. About 110,000 Japanese Americans were put into internment camps, war relocation camps during World War II. Now, blonde-haired, blue-eyed German American families, even though they might have belonged to the Bund, which was the American group of the Nazi Party, they were not put into internment camps. The Supreme Court upheld this practice, but they said that the decision had been strongly criticized. Congress would eventually pass a law apologizing for interning these individuals because they lost their homes, they lost their businesses, they lost everything. And they were paid $1.6 billion in reparations to their heirs, because most of them had passed away by then. So now we get to how civil rights policy was made during this era. You remember in the video I showed you the timeline. Once you get to the 1980s, things start to change and we back away for the implementation of civil rights issues. The Supreme Court mostly was dealing with civil rights issues in the 1950s, 60s, and early 70s. But after the early 70s, the Supreme Court started to deal more with states' rights issues, and now most of the issues that come in front of the Supreme Court are states' rights issues. In the judicial arena, the challenge of separate but equal in education was the first thing that had to be attacked. The NAACP would challenge the admission practices of law schools. There was an Oklahoma case that opened up black students to admission to white law schools. There was a push to desegregate schools that did not end neatly with Brown versus Board in 1954. Brown versus Board 2 claims that desegregation must occur with all deliberate speed. De facto segregation, then, is what we're going to have to look at. De facto segregation is segregation by factors such as a housing pattern. It's choice. It's, for instance, white flight, moving out of an area because you don't want your children to go to school with minorities. In Boston, this became a really serious problem. Everybody was fleeing to the suburbs, and you had a big white flight problem, and the schools that were inner city schools were totally underfunded, and they did not have a good outcome. So this was de facto segregation, segregation by choice. Well, the courts had to decide what to do. So what do you think they did? They decided to take half of the group from the inner city schools and bus them to the suburbs. Half of the group from the suburbs were required by the federal courts to be bused to the inner city schools. And of course, the moms and dads that moved out to the suburbs were very upset. Now, it's easy to cure de jure segregation. You can cure de jure segregation by changing the law. But de facto, you have to change people. In de facto, you have to change the behavior of people. And that's a lot harder, and it takes a lot more time. The recent court has been imposing, since the 1980s, what they call colorblind jurisprudence, which is the constitutionality of black majority redistricted congressional districts, placing that in doubt. Another example is Grutter versus Bollinger in 2003 with law school admissions. They consider this line from Sandra Day O'Connor, her majority opinion. The court takes the law school at its word that it would like nothing better than to find a race-neutral admissions formula, and that it would terminate its use of racial preferences as soon as practicable. The court expects that 25 years from now, the use of racial preference will no longer be necessary to further the interest of approved today. Do you think that racially based admission decisions in affirmative action are necessary? That becomes a real important question. Women are not people under the 14th Amendment, and in many early court decisions between 1971 and 1976, the court began to start to see women as different, in a different manner. So they came up with a test called the reasonable basis test, which is a difficult test to go beyond. The intermediate standard of review when discriminating on gender. With regard to African Americans and the like, you have a test that says basically the assumption is there's segregation. With regard to women, if the segregation is happening on a reasonable basis, then it's okay. Strict scrutiny says that you have to have a compelling state interest in discriminating, and that's the level that you go to for the level that you go to for African Americans. And I'm sorry, reasonable basis is for age. Intermediate standards are for gender. My bad. And then this is race. So at different times, the court has affirmed affirmative action for women, but it's also prevented women from expanding their rights. Now let's look at a case that was really good. Lilly Ledbetter versus the Goodyear Tire and Rubber Company, which is a case that illustrates the importance of federalism and the way in which democratic politics can be actually protected, used to protect a disfavored group. The courts, including the Supreme Court, had ruled against Lilly Ledbetter, who claimed that she was not getting equal pay for equal work. Congress passed a law that was supposed to shore up protections for women, and President Obama made it the first act he signed into law was the Lilly Ledbetter law, which says that now women have to be paid exactly the same as men. But sexual harassment is also a problem. Paula Jones sued President Clinton, claiming sexual harassment when he was the governor of Arkansas. Because she was a state employee, the civil rights laws concerning hostile workplace environment applied, and they actually found that he had created a hostile workplace environment. So civil rights and the expansion of civil rights. Expanding civil rights include laws that forbid interracial marriages being struck down. Significant parts of the Civil Rights Act and the Voter Rights Act have been upheld. The Commerce Clause of the Constitution is used by the court as justification for expanding civil rights and tamping down on segregation. This is women's earnings as a percentage of men in 2007. Okay? And you want to look at the states that have equitable earnings to men and don't. All right, and the percentages, actually Texas does have equitable earnings, but still, a lot of times the women are making 80%. In some states like Louisiana, Mississippi, and Alabama, women make less than 73% of a man's wage. All right, so California, women make less than a man's wage. It's sad but true. So gay rights. Rights restrictions are under the reasonable basis test, the most lenient standard. Gay rights falls under the reasonable basis test. In a case dealing with housing discrimination, the court sided with the homosexual rights. The court nearly applied suspect classification to laws, so it shows that the court is becoming more leery of allowing segregation to occur with gay rights. Substantive due process doctrine demarcates the line between the acts that a person of a public or private nature that the courts hold are subject to regulation by the public, and those acts that take place behind closed doors, which we consider free from governmental interference, which basically means privacy. All right, so when two consenting adults, what they do in their own home. In Texas, up until the mid 2006, there were still laws against sodomy. And two consenting adults of the same sex were not allowed to practice sex. Now that law has been it's been stricken down under this idea of substantive due process, meaning that that what you do behind your doors, as long as it's legal and it's between two consenting adults, should not be under the purview of the government. In the legislative arena, the cornerstone of equal protection today is built upon congressional legislation from the 60s. The Civil Rights Act of 1964, the Voting Rights Act of 1965, and the Fair Housing Act. The Voting Rights Act eliminated literacy tests and other means used to prevent blacks from voting. Black voter registration went from 6.7% in Mississippi to 59.8% within 3 years. Amendments to the Voting Rights Act have extended voting rights to language minorities. For instance, you now have to give anyone who doesn't speak English a translation of the ballot. Some efforts, though, to pass civil rights legislation even today still fail. Women have been on the receiving end of civil rights protections via legislation. Title VII of the Civil Rights Act bars discrimination on the basis of gender, but the prevention of discrimination on the basis of gender is not enforced until several years later. Title IX of the Higher Education Act prohibits sexual discriminations in institutions that receive federal funds, and this has had a great impact on college sports. So if you have men's baseball, you have to fund women's softball, and oftentimes the women get more money than the men do. Some efforts have aimed at expanding civil rights for women have failed. For instance, the Equal Rights Amendment, the ERA, failed. Violence Against Women Act was overturned by the Supreme Court recently. This is discrimination cases that were filed in 2009 with the Equal Employment Opportunity Commission. 30-something% of them dealt with race. Another almost 28% dealt with sex, gender. Age was another 20%. ADA, disability, another 20%. And then national origin, religion, and equal pay are a very small minority because they don't like to take those cases. In the executive arena, President Truman integrated the armed services in 1948. President Eisenhower used the National Guard as you saw in that little video, to enforce court orders to integrate high schools in Little Rock, Arkansas. JFK and LBJ used executive orders to establish affirmative action. When it comes to looking at the future of civil rights issues, there are three main perspectives. First, we need to move beyond race. Second, there are the traditional civil rights advocates. And then third, there are separatists that feel that black and white need to separate completely. There are people that really still feel that way. I feel sorry for them. Are we going to get rid of civil rights issues in this country anytime soon? The answer is most likely not. How do we deal with them? How do we tolerate each other? That becomes the issue of civil rights. So multicultural issues. Many states have made English the official language, although the federal government has not. A court's willingness to let states choose to administer driving tests only in English could be considered discriminatory. Proposition 187 in California. A lot of initiatives coming out of Arizona. So let's look how we can determine if discrimination is legal. We look at the suspect classification: race, ethnicity, creed, or national origin. Any of those are subject to strict scrutiny. Is unequal treatment justified by a compelling state interest, and is the least restrictive option being used? If yes, then it's legal. Few cases will meet this standard. It's a very strict standard. If not, then you can't discriminate. For sex and gender, intermediate scrutiny test. Is the discriminatory policy substantially related to an important government objective? Is the discrimination no greater than necessary to achieve this objective? For instance, requiring that men and women don't use the same restrooms. We can see the reason for that. But are you required to give women more bathroom facilities than men because women tend to have to take longer to use the restroom? Geez, now you're getting into something really sticky. And so far the courts have said no. Okay, so if both of those are yes, then the discrimination is legal, and some discrimination based on gender is permitted. This test is harder to pass than the rational basis test, which we're going to get to next. If not, the discrimination is illegal. So equal pay for equal work, for instance. You can't discriminate on equal pay for equal work by saying that the man has children to support, so he needs more money. So does the woman. Okay. Age. Age is subject to the rational scrutiny test, which says, is the law rationally related to furthering a legitimate government interest? And does the policy avoid arbitrary, capricious, or deliberate discrimination? If yes to both, it's legal. This is the easiest hurdle to pass. If no, then it's discrimination. So age discrimination is not one that the courts really like to step into. And that, ladies and gentlemen, is the end of this lesson. So have a very good week.